yesterday morning that he is ill and will not be here today. I assume he gave that information to the court.
He did, and we put an order down excusing him from being here at the oral argument. We would take his case in on his briefs and the record, but you would be allowed your time to argue.
Okay, thank you, Your Honor. I thought since I was here, I would go ahead and argue the case. We've raised 4 issues on appeal that we contend there were errors by the trial court, and including that Mr. Drake was individually liable as the agent of an undisclosed principal, a corporation which he had formed. The primary issues, in my view, that are before the court are certain agency principles under Tennessee law, and that is under what circumstances is an agent for an undisclosed principal liable on a contract, but more importantly here is the effect of the election by the plaintiff to sue the principal prior to suit against the agent. Our position on appeal is that the plaintiffs failed to prove there was a separate contract with Mr. Drake, but if they proved that contract existed, then their decision to pursue the corporation through a bankruptcy proceeding was an election and precluded their subsequent claim against Mr. Drake.
Mr. DeSauer, let me ask you a question before you go any further. I know that you've raised an issue, that being your first issue, about who the contract was between. Just for the purposes of clarification here, your client is not denying that there was a contract, or is he?
No, Your Honor.
Okay.
My client's position below was the contract was between the corporation and the Cackowskis for the purchases of the appliances. Those were the parties to the contract. In fact, his testimony was to that. In fact, that was his intent to create that contract, and it was thereafter recognized in the bankruptcy proceeding.
All right, thank you.
We cited the Holt case, the Sparkman v. Phillips case, the Lane case, which is a case from the Sixth Circuit applying Tennessee law. Each of those cases stand for the proposition that a contract with an undisclosed principal, if the sue the principal, the party can sue the principal or the agent, but not both. And once suit is against one, precludes suit against the other. The Lane case seems to me to be the best example of this principle. In that case, the plaintiff selected to sue agents on an insurance contract who were underwriters for an insurance syndicate known as Lloyd's of London. And in that case, the court held that the election by the plaintiffs to sue the agent as opposed to the underwriters, the principal, or the insurance syndicate, the principal, the syndicates were no longer liable on the contract. And in this case, the Cackowskis made the conscious decision to pursue the corporation, Professional Appliance Direct, Inc., in its Chapter 7 bankruptcy case, and in fact received the sum of $2,407.53 on their claim. So to the extent that Mr. Drake was ever personally liable on the contract, the election to pursue that claim was a waiver of any claim against Mr. Drake. The Cackowskis raised in their brief the restatement third of agency, section 6.09, and that provision states essentially that if a party has a judgment against a principal or an agent on a contract, neither party is discharged absent payment in full. We have located no Tennessee appellate authority that has adopted that principle and would displace the election rule in the Holt case and Sparkman v. Phillips. And it would, in order to adopt that rule, this court would have to overrule those two cases, as well as some subsequent cases that we cited in our reply brief that recognize that principle. In addition, I would point out that this issue regarding Section 6.09 of the restatement, third of agency, was never raised by the trial court. So it seems to me that before this court can address overruling some longstanding precedent, it would want to have the issue raised in the trial court, which it never was raised. Finally, I'd like to address the statute of frauds defense that was raised below. The trial court, in her decision, found that the statute of frauds case does not apply, and that would be inconsistent with the trial court's other findings that there was enforceable contracts both against the corporation and Mr. Drake. Because if there were enforceable contracts, then the statute of frauds obviously applies and would be a defense. There's two statute of fraud provisions that we relied on below. The first one is in Title 29, where in order to be obligated for the debt of a third party, there must be writing signed by the party to be charged, in this case, Mr. Drake. And then the Uniform Commercial Code provision of the statute of frauds, 47-2-2011, which states if there's a contract for the sale of goods in excess of $500, there has to be a writing and signed by the party against whom enforcement is sought. In this case, there was no evidence of any writing signed by Mr. Drake, and there's nothing with the signature on it. There was the issue raised below and in the briefs regarding the Tennessee electronic signature statute, but again, even that statute requires a signature. There's no document that's in the record that was signed by Mr. Drake, whether he agreed to sell the appliances or that he promised to be responsible for his corporation's sale of the appliances. And again, I would submit that the best evidence of the contract exists with the proof of claim that was filed in the bankruptcy case, in which the Cackowskis asserted a claim for the full amount they sought in this case against the corporation, and would suggest to this court that that should resolve this issue and that this case against Mr. Drake should be dismissed. Thank you.
Now, let me ask you, I always hate to do this when the lawyer's done, but the trial court found that clear to this court that Mr. Drake was individually a party to this contract and or an agent of a completely undisclosed corporate entity. What's your position as to whether or not there was a completely undisclosed corporate entity?
So the evidence at trial was that there were emails that were sent by Mr. Drake in response to the Cackowski's inquiry on these appliances, and the emails had the name Professional Appliance Direct, but it didn't have the comma Inc. beside it. So the trial court concluded that was evidence that the principal was undisclosed. But when Mr. Cackowski testified at trial, I asked him, I said, did you pay attention one way or the other? And he said, no. I said, is it fair to say that you never considered who you were doing, entering into a contract with? And he said he did not. So again, I would submit that the intent was for the corporation to sell the appliances, and that was always the intent, and it's best evidenced by the proof of claim that was filed in the bankruptcy case.
Okay.
Thank you.
Have a safe trip back.
Thank you, Judge.
Recess court till 1:30 this afternoon, please.
All rise. This court is at recess until 1:30 today.